Hello, my name is Nicole Vera from St. Petersburg College. The following case is for ATE 3515 legal and ethical issues, with the instructor being Dr. Cynthia Gray. The law case in discussion in the further presentation will be about whaling in the Antarctic, with the dispute being between Australia versus Japan and New Zealand intervening. So this case is going to be in regards of Australia basically in disagreement with Japan and their permit of JARPA, which is creating allowance for whaling to proceed for quote unquote research program. And this is under the special permit, which is giving the permission to kill the whales. This case began back in May of 2010 and ending in March of 2014, with the dispute of how JARPA is not right and actually being abused uh, during the situation in this case study. Australia was not alone in the fight. New Zealand actually stepped in, siding in with Australia, fighting against with Japan and the JARPA Act. New Zealand stepped in approximately around November 20th of 2012, filing a registry and declaration of intervention in the case, which is relying on Article 63, Paragraph 2. This case did go on for years, from May 31st, 2010, all the way to March 31st of 2014, approximately 4 years. On a side note, Australia has been fighting the situation since about 2002, but really got into pushing in more for getting rid of JARPA and the purpose that Japan is actually using it for, and killing whales in large scales. So laws that are being discussed throughout this presentation is going to be Article 36, Paragraph 2, which is stating an optional clause which allows countries to state in advance that automatically recognize that the court's authorities to settle specific legal disputes with other states and accept the same obligations. Another article that will be discussed throughout the presentation is going to be Article 8, Paragraph 1, specifically, which is the International Convention of the Regulations of Whaling, which was signed back in 1946. This article was specifically for allowing permit or giving permission to kill the whales for scientific use and studies. Again, this was a permit that was put together. JARPA does stand for Japanese Whale Research Program. History of whaling. Whaling is something that's been done for years, starting around the 18th century. Whaling was performed under the Act, which typically would allow to send different specimens to labs for testing to get a better understanding of these species. It was not only specifically for orcas or other breeds of whales, but for all of them, just to get a better understanding of how their organs function, what they eat, and any sicknesses, and just other studies that they wanted to do. Australia and New Zealand did side together with this. New Zealand did step into this case study little later on, approximately about 2 years later from when Australia had started fighting this whole predicament with the JARPA in Japan. With JARPA, the biggest thing was not allowing industrial ships, basically, for catching these whales for killing and studying them, just because of the sole purpose, knowing that they could be commercially used, especially when industrial ships do take place, they can carry more carcasses. Another big point with the permitting was no finning. New Zealand stepping in and making sure that Australia had backup, what again was back in 2012, but they actually met the requirements to be part of this case and in the court in February 13th of 2013. So the biggest issues was commercial whaling versus the ICRW. The ICRW stands for International Convention of Regulations of Whaling. The biggest purpose for this was to assure that there is research that's actually being done and implemented that are managing the catch limits for the research purposes. With the ongoing case of Japan and Australia, uh, there was a dramatic number of whales that were being killed, which was of concern, especially since commercial purposes was one of the biggest red flags here. Commercial whaling is basically killing the whales for the sole purpose of their blubber, their meat, and their body parts to sell them on the market. Since they are high money, high priced, that was a way of the industry to kill the whales, but under the right act, stating that they were using it for studies. Japan's biggest argument was basically that they were still within regulations of JARPA, not crossing any sanctuaries, specifically the Southern Ocean Sanctuary, that they were still in like the deep oceans, and they state that they were exempt from Article 8, which again, Article 8 is more about the International Conventions of Regulations of Whaling, which was signed back in 1946. And this was basically from the JARPA stating that there the studies were for scientific permits. My opinion with everything going on throughout this case study is Japan was using JARPA as an excuse, though they state that they were exempt from the Article 8. They did find different loopholes that they were able to continue killing these whales with the intervention of New Zealand. Um, New Zealand was able to help Australia push through with um, removing JARPA. With the ongoing case of the cat and mouse game between Australia versus Japan, JARPA was finally revoked. Japan was issued that they had to revoke the law, and basically they had to abide by the laws. One of the biggest arguments also in regards of Japan was basically that breaching obligations were set and were set. New Zealand throughout the court process states that Article 26 is mentioned in the Vienna Convention of the Law treaties, customary international laws with Japan's obligatory an ongoing case basically to where they had to trust their words. The final disposition of the case, the court concluded that the special permits granted by Japan for killing and treating of the whales for connection of JARPA 2 were not found for the purpose of scientific research. Having found that Japan indeed did breach um, some of the rules that were invoked through JARPA, it was ordered that Japan had to revoke the permits to kill or take or treat whales in relations to it, and to refrain from granting any further permits under regard of Article 8, Paragraph 1. Approximately 6,800 whales were killed in the Antarctic under the JARPA Act. Out of the 6,800 whales, 840 of them were actually killed by Japan through the JARPA Act 1, which was not used for scientific purpose but for commercial reasons, with an understanding that killing whales is used for studies, but there was also a large profit margin for them. The key takeaways throughout the article and this case study that was given is the biggest thing is, even though the articles are given and certain permits are there, there's always some type of loopholes of trying to take advantage of the system, whether it's for profits or any other reasons. I feel that JARPA should have more carefully worded what they were used for, or had someone specifically in that area or location for regulations, making sure that the permit was being used by its word and not only by what the people state they're using it for. And this article also shows that the persistence and consistency of hard work can pay off, even though that it could take years to achieve. It is something that can definitely be accomplished. Reference that was used throughout this case was the International Court of Justice. And there's a website there in case if you want to do further research or look into any further whaling issues that was done. There's other international cases and some that were actually done not too far from here.